Okay, so the shadow docket is not a legal term, it's a colloquial term. It's given to emergency appeals that the Supreme Court of the United States decides on an expedited basis outside of the procedures that apply to its standard merits docket. So to understand what the shadow docket is, let's start with the merits docket. Each year, the Supreme Court decides about 60 cases now. The merits docket has dwindled in terms of its numbers over the past 10 years. Those cases are decided with full briefing, oral arguments, invitations to amicus curiae to participate, often with invitations to the Solicitor General, where the United States is not a party. And as far as the court having any kind of transparency, which is already very little, you have the maximum amount with what we call the merits docket. The rest of the court's workload is technically on what's called the orders list. So the orders list could consist of 7,000 or so cases a year in which parties ask the Supreme Court to accept their case for review. And usually the Supreme Court would just deny requests with a one-line sentence saying petition denied. The shadow docket is a term given to that subset from the orders list that refers to high-profile emergency requests that kind of jump the queue, jump a line that otherwise applies to the merits docket and ask the Supreme Court for immediate relief. And usually those cases ask for the court to lift a lower court injunction, a lower court order that blocks something or that requires something. And those cases, when the Supreme Court enters its ruling, the court doesn't provide for oral argument as a rule, provides for very summary, short decisions, and doesn't allow for full briefing. And yet it makes very consequential decisions.